The O'Keefe family has asked a court to compel Karen Reed to name names of the people that she believes are directly responsible for John O'Keefe's death. Karen was basically like, I don't know who was responsible for John O'Keefe's death because the investigation was not done properly and a bunch of people were destroying or tampering with evidence. The plaintiffs are like, that's not good enough, you need to name names, and Karen is like, how? How am I supposed to know what you guys did in there? No cops ever went into the house. This is Karen Reed's opposition to now moot motion to compel further answer to plaintiff's single interrogatory. Interrogatories are written questions that are given from one party to another in a legal proceeding, and the answers to them are under oath. So in this case, the single interrogatory was the one question the plaintiffs asked, who do you think killed John O'Keefe and why? And Karen Reed's lawyers are saying this is now moot because they already answered the single question, the single interrogatory. Plaintiff served a single interrogatory asking Reed who she believes killed Mr. O'Keefe. Under oath, Reed answered the question directly. She did not do so, and she knows the individuals in the house at 34 Fairview and police investigators hid, destroyed, deleted, tampered with, failed to gather, altered, and otherwise lost critical evidence that would have led to identifying the specific person or persons who were responsible, among many other things. After learning of a request for a court order for the inspection of his phone, Brian Higgins removed the SIM card from the phone, destroyed both the phone and the SIM card, then drove to an army base on Cape Cod where he threw both into a dumpster. He did not transfer information from his destroyed phone to his replacement phone. After learning about a request for a court order on the inspection of his phone, Brian Albert destroyed his phone and replaced it without saving any information from the phone. All other occupants of the house destroyed their phones and did transfer data to their new phone. Yes, that says brain. Brian and Nicole Albert rehomed their family German Shepherd dog shortly after Mr. O'Keefe died, and there was evidence of dog bites and scratches on Mr. O'Keefe's body. The Alberts had remodeling work done to their house at 34 Fairview and then sold it after Mr. O'Keefe died. Disgraced, disavowed, dishonorably discharged ex-trooper Michael Proctor planted pieces of glass on the bumper of Miss Reed's Lexus, suggesting that they had come from a cocktail glass that Mr. O'Keefe was holding. But when Miss Reed's criminal defense team requested testing of the glass, they discovered it had come from 5 different sources, including a single piece allegedly discovered by Proctor 2 weeks after January 29, 2022. Despite having multiple video cameras set up inside and outside the Sallyport garage at the Canton Police Department, none of the available footage shows the back of Miss Reed's Lexus or its right taillight. Proctor took pieces of the taillight off the car while it was in the Sallyport, brought it back to 34 Fairview, and placed it around the area where Miss Reed found Mr. O'Keefe's body to make it look like the Lexus had struck Mr. O'Keefe. Proctor lied under oath in many affidavits he signed relating to when the state police seized Karen Reed's Lexus. And Proctor failed to follow protocol relating to the Lexus taillight pieces and Mr. O'Keefe's clothes, including failing to secure evidence and failing to document evidence. Michael Proctor, first of his name, breaker of chains of custody. Reed does not know exactly who fatally wounded Mr. O'Keefe, but she believes it was one of the occupants within the house at 34 Fairview. Then they pop over to them quoting the interrogatory, but we have that original document, so we're going to hop over there and then come back. Okay, this is Karen Reed's supplemental answer to that single interrogatory. And the interrogatory was, identify each person who you claim is responsible for the death of John Joseph O'Keefe III, and for each person state all facts forming the basis of your claims. But her lawyers argue Miss Reed is not required to identify the specific persons who were responsible for Mr. O'Keefe's death. They say the interrogatory is seeking information outside of Karen Reed's knowledge and possession. Miss Reed is not an investigator or police officer and is not otherwise responsible for or skilled in determining who was at fault for a person's death. And Karen explicitly states, I did not cause and am not responsible for Mr. O'Keefe's death. I did not strike Mr. O'Keefe with my car. Mr. O'Keefe's wounds are inconsistent with being hit by a vehicle and consistent with being in a physical altercation and attacked by a dog. Credible evidence indicates that he was beaten inside the home of 34 Fairview. The individuals inside the house during the time period surrounding Mr. O'Keefe's death also took actions that suggest wrongdoing. She's essentially arguing consciousness of guilt. Would an innocent person have done the things that they were doing, including tampering with, destroying, fabricating, and manipulating evidence, all in an effort to direct blame towards me? The individuals and entities who had the responsibility to fully investigate the circumstances of Mr. O'Keefe's death failed to adhere to their duty, and instead ignored, destroyed, and failed to gather or investigate highly relevant evidence in and around the house at 34 Fairview. Essentially, why did you guys literally never even go inside the house? Why was no one's story corroborated with independent information like, I don't know, video footage of them driving home on local camera or location data from basically anybody's phone? When did Colin leave? Did Tristan actually come pick up Caitlin and then leave at 1:30 in the morning, or did he hang out for a while doing other work that needed to be done? We don't know because there was no investigation. Okay, sorry, let me calm down. They did so because of personal connections between the lead investigator and individuals within the house, as well as the occupants' connections to various local, state, and federal law enforcement agencies. By believe that one or more of the occupants of the house at 34 Fairview caused the death of Mr. O'Keefe. However, as a result of the destruction and concealment of key evidence, the truth about what happened to Mr. O'Keefe has been deliberately obscured, and I do not know which specific individual or individuals within the house fatally wounded Mr. O'Keefe. What I do know, without any doubt, is that I played no part in causing, participating in, or contributing to his death in any way. Okay, now we're back to here. This is all that stuff I just read to you. And her lawyers are like, this is the only truthful and accurate way for Reed to respond. Before involving the court in every little dispute that two parties have in a lawsuit, the two parties are supposed to have conversations with each other, try to come to a resolution, and then get the court involved if they cannot come to a resolution. And Karen's lawyers are basically saying, look, you asked the question, we gave an answer, you didn't like it, we gave you more of an answer, a supplemental answer, and you still didn't like that answer, but you won't tell us why or give us any kind of information on what we need to change. Essentially, they're saying, we don't understand why you would file this motion with the court when you could just ask us for the information. Unless maybe you're trying to sway public opinion. Karen's lawyers say that they explained to the O'Keefe lawyers why the motion is moot and that filing it would be a waste of the court and parties' resources. And instead they requested a 9C conference to understand the plaintiff's concerns with the supplemental answer, and that conversation has never taken place. The purpose of a 9C concert, in my understanding, again, I'm not a lawyer, is to kind of streamline the case, narrow the scope of things. Basically, these parties have an obligation to confer with each other before filing motions to not waste everybody's time and money. As always, I am so open to corrections from actual legal professionals. That's just the best of my understanding. Reed's counsel tried once more in writing, saying, just to be clear, you are refusing to confer with us pursuant to Rule 9C and explain your concerns with the supplemental answer. Plaintiff's obstinance continued. I can already feel the obstinance continued entering my lexicon. We have conferred about it. We provided you a detailed motion. You believe the addition of 4 sentences addresses that concern. The court will need to help us resolve this dispute. And they're like, actually, Reed doesn't even know what issues the plaintiffs have with the supplemental answer. They also ask, what rule is Karen exactly violating here when she isn't naming a name? Plaintiffs' arguments in support of their motion fail to identify any basis for ordering Reed to provide further information in response to their interrogatory. Essentially, what case law do you have that her saying it was an individual in the house isn't good enough? What specific precedent would say that Karen has to do that? They argue that Reed has failed to provide sufficient evidentiary support to succeed on her affirmative defense that other third parties are responsible for Mr. O'Keefe's death. And they're like, yes, this is the point of discovery. We're going to try to get more evidence of what actually happened, beyond the evidence that they had access to in Karen Reed's criminal trial. And they're like, also, if you believe that Karen cannot satisfy her legal burden as a result of her discovery response, then you're free to assert that her affirmative defense should be dismissed at the appropriate time. Basically saying, look, if we get all the way to the point of a civil trial and you still don't think that she has enough evidence to assert this defense, you can bring that up with the court then. You can't force her to say who she believes did it right now. And also they point out that they did not and could not ask Reed to state the basis of her affirmative defense because plaintiff served the interrogatory more than a month before Reed first asserted her affirmative defenses. They say by filing this motion to compel Reed to answer this question, they seek to convince the public at large that Reed is somehow being evasive when she is not. Karen Reed has answered the plaintiff's single interrogatory, and plaintiff's frivolous inferences to the contrary are simply untrue. I had to say frivolous inference like 20 times in order to say this one sentence. There's some catch up on Karen Reed's latest civil trial stuff. This only affects the case between the O'Keefe family and Karen Reed. This has not yet been combined with Karen Reed's lawsuit where she is suing the McCabe's, Alberts, Brian Higgins, members of the police in their personal capacity, and police departments. Those may or may not be combined later, we just don't know yet, and as of right now, that lawsuit has been moved to federal court. It could move back, we again don't know yet. That's everything I know about this. Love you guys, drink water, bye!